So I refunded the money to his family and him. I'm here asking to withdraw as his attorney, Judge. The family had told me that
you have the right to select and choose the attorney that you wish to hire. And apparently Mr. Overton was hired by you or your family to represent you on this charge. And he's indicated he's only filing a motion withdrawal due to the fact that you have told him you were going to hire a different lawyer. What is your intention regarding the lawyer, having an attorney represent you at your trial in July?
My attorney was supposed to come speak with me today for a consultation. I haven't talked to him yet, so I can hire him. So I'm still getting a lawyer.
But you're going to hire your lawyer, is that correct?
Yes, sir.
All right, Mr. Overton, I'm going to allow you to withdraw.
Thank you, Judge.
Mr. Overton will be allowed to withdraw, and we're going to give you 30 days to retain new counsel. What's the date I can have an attorney status on, Mr. Overton? Let's put it on the March 27th. We're going to reset your case for March 27th, just to
hey guys, we're
your
out on this.
status, to make sure you
It's just the
have a lawyer
our guy
Judge
Wolf here,
okay?
Dickson County.
Okay.
I'm still trying to help the White Rabbit get
to
her
do
stuff
that.
out to the
Just
car.
make sure that you've
So
got somebody hired.
I will be back.
Thank you.
Thank you, Honor.
This has
Thank you.
been it's just all the criminal stuff in Dickson County. It's really cool. Hey Miami, how you doing?
On the old docket, he was page 34, Judge, but
34. Well, that's the old docket. Just don't refer to the old docket.
Gotcha.
But,
2020 CR 328,
last name is Martin.
Marvin.
Martin. All right, it's on page 16 of the new docket.
I couldn't sleep last night. Started
What are
listening
we
to
doing?
Lost Souls, True Crime and Chat.
Judge, this is General Wojnarowski's case. We have spoken numerous times. We have Mr. Marvin now in place wherein he can stay set for his plea date, Judge. I've got a general sessions matter that he pled to over a year ago that I believe I've got worked out with Ms. Chapman in terms of that not messing up anything we've got planned for these two cases. So if we could just leave him set on his plea date, Judge.
All right, his plea date is March 27th on these cases, and trial date is April 15th. So he will remain set for March 27th, and plea date is, trial date of April 15th.
Thank you, Judge. Yes.
All right, now at the jail, I'll need you to unmute.
I'm gonna take some luggage outside. I'll be right back.
Good afternoon. At the jail, what's your name?
Jeffrey Wells.
Wells is on page 28 and 29. Waynick, we lost Mr. Waynick.
Judge, I believe he and I may have I signed an agreed order resetting this. I don't know if he submitted that. This is the day that he is at a tactile training that he scheduled several months before the trial date was set. And so I know we were moving it to a September date. I just don't remember which one.
All right, Mr. Wells, your lawyer has got a conflict with your trial date and has asked us to reset it. So we're going to go ahead and reset it. He's had that happen for several of his cases. We're going to reset your case, and Mr. Waynick will be in touch with you to give you your new trial date, okay?
Yes, sir.
All right, thank you.
Thank you, Judge.
What's your name, please?
Donald Watts.
Donald Watts is on page 20. 28. Mr. Jake Lockhart is your lawyer, is that correct?
Yes, sir.
Is this one of the cases that's set for
Due dates, March 12th, trial date, April 22nd.
This is General Stribling's case. I think she just asked that we handle it when she gets done in juvenile court. You can second call it, and I don't see Mr. Lockard in here anymore.
No, he's left and gone to Williamson County, I think. Remains set for trial on April the 22nd. The plea date will be March the 12th.
Okay.
Lawyer, we'll have you ready for trial today. Your final day to enter a plea to settle your case by some sort of an agreement will be March the 12th. If that does not happen, then you'll either go to trial on April 22nd or plead to the indictment and go to sentencing. Thank you.
Yes, sir.
Good morning. What's your name, please?
Lorenzo Bank.
You say your last name is Banks?
Yes, sir.
You go Lorenzo Banks?
Yes, sir.
He's on page 2.
Hey, aren't y'all excited? Hey,
Banks,
cool
you
gamer.
were
Leslie, what's going
represented by
on?
Mark Odell, if I understand correctly.
White Rabbit told me that y'all
Yes.
get to babysit me.
And we are leaving your case will be remaining on
Aren't you
March
excited?
the 1st. We're having motions in all of these cases that involve the conspiracy to distribute drugs. So your case will be heard on March the 1st. Your lawyer will be here on that day and we'll have a hearing on those motions. After that, we'll set you a final appearance day, and then if it doesn't settle, we'll give you a trial date. Thank you. Good morning. What is your name?
Rasul.
Repeat your name, please.
Robert Sewell.
Mr. Sewell's on page 2122. Don Himmelberg is your lawyer, is that correct?
Yes, sir.
All right, these matters are set for March the 1st. Today was the day that we were going to allow any sort of disposition, but your cases are set for March the 1st for hearing on motions to contest the validity of the constitutionality of that statute under which you're charged. So we'll see you on March the 1st.
All right.
What's your name?
John Travierso.
Travierso is on page 24. Winnick is your lawyer, set for April the 18th and 19th. The last day to enter a plea will be March the 12th. This is a second-degree murder case set for trial on that day. As far as we know, it is a go, correct?
Yes, Judge.
All right, Mr. Travierso, your lawyer had to go to another court, but your case remains set for trial on April the 18th and 19th. It's specially set on those days. And the last day to enter a plea, if you chose to do that, would be March the 12th. So Mr. Winnick will contact you and make sure you're ready for trial. Thank you.
All right.
What's your name?
Christopher Bateman.
Bateman's on page 2. Mr. Bateman, you have a lawyer?
Yes, sir.
Who's the lawyer?
Nathan Brown.
Nathan Brown.
Yes, sir.
Brown has joined in with several other lawyers to challenge the constitutionality of the statute of which you're charged with conspiracy. And we're having that motion hearing on March the 1st. So we will pass your case to that day to have that hearing. Mr. Brown,
Yes, sir.
Thank you.
Yes, sir. You too.
That guy's got a cool haircut. No, this guy means business.
What is your name?
Roy Crowder.
Lloyd Crowder. Wasn't that the dude's name in Justified?
That's my case. That's for a bond hearing.
All right, do you want to have him brought down here?
Judge, what, I'd like to, not sure exactly what time we'd have him brought down. A federal case management conference, in front of Judge, I can't remember her name, Judge Holmes in the Middle District at 2:00.
At 2?
Yes, so I'll have probably an hour or so. I mean, we tried to get it moved too, but she said no.
Well, do you want to have you want to have him brought down here at 3 o'clock just to be on the safe side?
That'll be fine.
We will bring Mr. Crowder down at 3 o'clock, please.
So, guys, Judge Wolf, he's a circuit judge. He goes to like 4 different counties, I think. So he's trying to get everything done he can today in Dickson County. His next court will be in another county.
Grandson was 4:18 this morning, and I've yet to see him.
Hey, Texas Jen, how you doing? Oh, it is hump day. My wife.
What is your name, Mr. Gerald?
See what's going on?
What's your name?
Jeremy Goodstein.
Goodstein is on
There
page
you go.
10.
Get her out. Still.
And Goodstein is, you have a lawyer, I think Mr. Atchison, okay?
Judge, I filed a motion on behalf of the bonding company, Bullseye Bonding, to be relieved from Mr. Goodstein's bond. Judge, Mr. Goodstein, based on the motion I filed, failed to appear in this court, Judge, on January the 8th. He was notified of said court date by the bonding company, failed to show sire fee was issued, and then subsequently, Mr. Goodstein was surrendered to the Dickson County Jail on February the 8th by the bonding company. Therefore, Judge, I would ask this court to relieve Bullseye bail bonding of Mr. Goodstein's bond.
All right, Bullseye bail bonding has met the statutory requirements to be relieved from the bond, so therefore the motion to relieve the bond is granted. Mr. Goodstein, do you have a lawyer representing you currently?
No, I need to get a lawyer, and I want to see if I could get a bond so I could get my elderly mom taken care of.
Well, I can tell you right now that it's going to require some hearing after you have a lawyer, because right now your bonding, the bond that you did have has been set aside, and I'm going to allow the public defender have any problem representing this defendant. As far as you know, Mr. Goodstein, he's charged with theft of property.
I don't think we'll have any conflict, Your Honor, but if so, we'll file a motion.
We'll appoint the public defender to represent you because you're currently in custody, and once the public defender's had a chance to talk with you, then that can file the appropriate motion to ask for a bond hearing at that point. So we need to arraign him on the charges of theft in docket numbers 2023 CR 429 and 430.
Commissioner, Public Defender's Office, I acknowledge receipt of the indictment, waive formal reading, enter a plea of not guilty.
Plea of not guilty is entered, public defender is appointed. Let's go ahead and set the trial dates, please.
Date of May 13, 2024, trial date of May 16, 88 license.
All right, we'll leave it set for those dates. May 16th for trial, May 13th for plea. And Mr. Goodstein, the public defender will be up to speak with you and try to get with you as quickly as possible that we can get a bond hearing set if that's what's necessary.
Yes.
We have,
Only might get a bond hearing.
well, I can't tell you until it's filed, but we'll give you a trial date as soon as they're able to file your motion.
Thank you.
What's your name?
Fuller buyer.
Ours on page 2. Mr. Wennick is your lawyer, and I believe this is a case that remains set for March the 1st on motions that have been filed which challenge the constitutionality of the statute. Your case is going to be heard along with many others on March 1st. Mr. Wennick will be here on that day to represent you, okay?
All right.
Thank you.
Well.
Do we have anybody back here? All right, let's bring out the next one.
Mr. Harmon.
All right.
Yes. You sign this one too.
All right, I've been handed a document entering, I believe this is the case that we had halfway gotten through and before we ended up having to stop.
Yes, sir. There was a miscommunication about the, I believe it was case number 342. He will be pleading to that one. Also a no contest plea that will run concurrent with all the other counts.
All right, so the docket numbers on these documents are 342, domestic assault, a no contest plea, and 343 and 379. Is that correct? All right. I'm just going to reboot, rather than try to remember where I was in this explanation of your rights. So you've been placed under oath, and your name is Courtney Jean Harmon, correct?
Yes, sir.
Mr. Harmon, do you understand what you're charged with now?
Yes.
You understand what the agreement is now?
Yes.
You understand that you have a right to plead not guilty and have a speedy and public trial by jury in this court?
Yes.
You understand that you would have the right to have a lawyer and have one appointed, as I've done with a public defender?
Yes.
You understand if we went to trial, you would be presumed to be innocent until such time if ever the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors?
Yes.
You understand that if you went to trial, you and your lawyer could confront and cross-examine all the witnesses brought against you. You could also bring in your own witnesses by the use of a subpoena.
Yes.
You understand that you would be presumed to be innocent. You would not have to testify or prove anything at your trial, and no inference of guilt would arise because you did not testify at your own trial.
Yes.
You understand that if you went to trial and you were found guilty, you could appeal the conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal.
Yes.
You understand that by entering this plea of no contest, you're waiving your right to a trial and to an appeal. All I'm going to do is approve what your lawyer's worked out.
Yes.
You understand that's going to then result in a number of convictions, and those convictions are going to be on your record in the future to make more severe the punishment you'll receive if you are ever again convicted of a crime.
Yes.
You're being convicted of domestic assault along with felony convictions, and both of those under federal law and state law will prohibit you from ever buying, possessing, or controlling or having in your presence a weapon of any kind. Do you understand that?
Yes.
A firearm, at least. Not a weapon, but a firearm. And it begins immediately upon conviction and continues for the remainder of your life.
Yes.
All right. Do you understand that these are going to be convictions that will be on your record in the future to make more severe the punishment you receive if you are ever again convicted of a crime?
Yes.
Do you still wish to plead no contest and give up your right to a trial?
Yes.
Is your decision to plead no contest today voluntary?
Yes.
Anybody forcing you to do this? You understand I can't accept your plea unless I'm satisfied there are facts to support it and that you are in fact guilty of these charges.
Yes.
I want you to listen as the state tells me what their evidence would be in each of these cases.
Your Honor, on 23 CR 342, the state would have put on proof that on June 22nd of last year, the defendant and his then girlfriend, Fannie Long, were in the city of Dickson. They got into an argument and he struck her in the face. And then for the other case, we put on proof that this is for, 343. On August 24th of 2023, the defendant walked into the Wendy's located in the Pilot Travel Center here in Dickson County. He took $11,585 from the cash drawer. Detectives were able to watch the surveillance video and identify the defendant as a former employee. Police secured a search warrant for the residence of the defendant at the South Air Inn. When the search warrant was executed, police found drugs in the residence and $8,500 in cash, which was later determined to be the stolen money from Wendy's. That money was recovered and returned to Wendy's. Mr. Harmon gave a full confession as to the burglary and theft. Restitution in the amount of $3,085 is requested in this case.
Right. Mr. Harmon, I'm not asking you to agree with those facts, but you understand that's what the state's evidence would be.
Sure.
You still wish to plead no contest according to this agreement.
Yes.
Are you satisfied with your attorney's services?
Yes.
You feel like Mr. Harmon's, Mr. Howard's done a good job representing you?
Yes.
Mr. Howard, do you know of any reason you should not enter this plea?
I do not, Your Honor.
The court, Eugene Harmon, in docket number 2023 CR 41342, upon your plea of no contest to domestic assault, you found guilty, sentenced to 11 months and 29 days in the county jail, and have no contact with Fannie Long. Docket number 343, you found guilty of counts 1, sentenced to 4 years in the Tennessee Department of Corrections to serve as a range 1 offender. Count 2, 4 years to serve as a range 1 offender. Both will serve concurrently with each other and with the prior case that I've just mentioned. $2,000 fine. $2,000 in restitution to Wendy's. Count 3 is dismissed. And docket number 379, found guilty of count 1, sentenced to it's an amended charge of simple possession, and that will be 11 months and 29 days to serve on both counts 1 and 2, which are both amended to simple possession. And in each case, 11 months and 29 days suspended. Those will all run concurrently with each other and with all of your cases. So he'll have an effective 4-year sentence. All right, thank you. That's the judgment of the court.
You may need, Mr. Brooks, ADA Brooks up here to explain this, because I can't explain something Renee needs something.
Just a show cause order, Your Honor, from another state's requesting, they have a trial on those listed dates in that show cause. We're asking that the court order the witness to appear here in court prior to those court dates to explain why or why not she should be, she shouldn't be able to appear.
I have a problem with it. The show cause order is to an address in 405 South Marbury Street, not Miss. It is not to Miss Calderwood. It is to an address, and you want this address to show up in court. The show cause order does not have, in my opinion, if you're going to do a show cause order, it should be to Susan Calderwood at this address, and it doesn't mention her at the beginning. So really what it says is show cause order to 405 South Mulberry Street, Dickson, Tennessee. And then in the body of your order, it mentions Ms. Calderwood, but I think to make it clear, it needs to just be redone. I'm going to be here all day until I can leave. So if you'll redo it and add her name to that show cause order too, then that makes it clear, in my opinion, that who it is we're summoning on a show cause.
Governor, if I could have two matters addressed. There is a Ms. Erica Tidwell Davenport and a Ted Bradley Davenport. They have a sick child at home, so if the court would be willing to take that up.
They have what?
A sick child at home.
All right, let's take up 2023 CR 229 State versus Ted Bradley Davenport.
These are Mr. Stevens cases, and it looks like he has a conflict in representing either of them.
And who is the other one?
Erica Tidwell Davenport and Mr. Ted Bradley Davenport. Case number 23 CR 229.
and
see
page
Erica
24.
Tidwell Davenport. Do we know, obviously, do we know why has a conflict?
I believe he's previously represented the alleged victim, Mr. Joseph Townsend.
Right. Can one attorney represent both of these individuals?
Probably.
I will appoint Mr. Kirk Vandervoort of the Dickson County Bar, who's been appearing in criminal court recently, so we're assuming that he's now handling criminal cases. Mr. Kirk Vandervoort will be appointed to represent these defendants. He'll be notified of that. Their trial date was March the 7th. Necessarily, that will require a reset in order to allow the new attorney.
September 19th.
New trial date will be September 19th. Last day to enter a plea would then be September 12th or 11th. 11th,
I think it would be the 9th.
the 9th. Last day to enter a plea will be September the 9th. New trial date is September the 19th. Your lawyer is Kirk Vandervoort with Rose, Potter, Reagan, and Vandervoort. And you'll need to make an appointment to go see him. You'll be notified of it by a copy of the order.
Thank you, Your Honor.
Thank you. All right. Do we have anybody else back there?
Case driver Nathan Sweeney, Judge.
That'll also be my case, Your Honor, Nathan Sweeney. Not sure what page number.
Who is it?
Nathan Sweeney, the one that's on the way out.
All right, I've been handed a document indicating Mr. Sweeney is going to enter a plea of no contest to count 2, theft, a misdemeanor, receive a sentence of 11 months and 29 days, suspended of probation, $650 restitution of Michael Gennaro. Mr. Sweeney, raise your right hand. Let's place you under oath. State your full name for the record.
Nathan Sweeney.
Mr. Sweeney, you're here today charged with a 2-count indictment. It's been indicated that one of those is being dismissed as a part of this agreement, but you're entering a plea of no contest to the other charge. But have you seen or been shown a copy of those charges and talked them over with Mr. Howard, and you and he discussed the range of punishment you're facing as well as any possible defenses you might have?
Yes, sir.
Well, it's indicated that you want to enter a plea of no contest. That simply means you understand what the state's evidence is going to be. You're not going to admit you did anything wrong, but you're not going to deny it or contest it. And the state will then tell me the facts necessary to establish your guilt. Do you understand that?
Yes, sir.
You understand, however, that you have a right to plead not guilty and to have a speedy and public trial by jury.
Yes, sir.
You understand you would have the right to have a lawyer at that trial and to have one appointed, as we've done with the public defender.
Yes, sir.
You understand at trial you would be presumed to be innocent until such time if ever the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything. You understand that at trial you and your lawyer could confront and cross-examine every witness the state called to testify against you, and you can bring in your own witnesses by the use of a subpoena. You understand you would be presumed to be innocent. You would not have to testify or prove anything at trial, and no inference of guilt would arise because you did not testify at your own trial. You understand that if you went to trial and you were found guilty of a crime, you could appeal that judgment of conviction as well as the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal. You understand that by entering this plea of no contest, you're waiving your right to a trial and to an appeal. All I'm going to do is approve what your lawyer worked out. You understand that's going to result in a conviction, a misdemeanor conviction that will be on your record in the future to make more severe the punishment you receive if you're ever again convicted of a crime. You understand all the rights that I've explained to you. Do you want to plead no contest and waive your right to a trial and to an appeal? Is your decision to plead no contest today voluntary?
Yes, sir.
Anybody forcing you to do this? You understand that I can't accept your plea unless I'm satisfied that there are facts to support it and that you are in fact guilty. Then listen as the state tells me what their evidence would be if this case went to trial.
Your Honor, on 1/21 of 2020.
And I am home alone. How are you guys doing?
Given a payroll check for in the amount of $250.
Uh-oh, ID crisis. What's happening?
So that would be the basis.
Nicola, how are you doing?
Not asking that you agree with the accuracy of those facts, Mr. Sweeney, but do you understand that's what the state's evidence would be if you went to trial?
Yes, sir.
You still wish to plead no contest to the charge? Are you satisfied with your attorney services?
Yes, sir.
Feel like Mr. Howard's done a good job representing you. Mr. Howard, you know of any reason you should not enter this plea?
I do not, Your Honor.
And Nathan Dean Sweeney and docket number 22 CR 156, upon your plea of no contest to count 3, I find you guilty, sentence you to 11 months and 29 days in the county jail, suspended to probation on time served, $650 fine, $650 restitution to Michael Gennaro. Count 1 is dismissed as a part of the agreement. Thank you. He'll need to see the probation department at some point. We have others back there.
We have 2 more, Judge.
Just keep bringing them until we stop at noon. 2023 CR 121 State versus Christopher Wayne Claiborne.
That's just set for trial in April, Your Honor.
That's Mr. Creasy's case. It's set for trial on March 21st. Last plea date will be March the 11th.
I think it's actually April now.
Did it move to April?
I think so. We did it back there one day.
Fast group, I didn't see it. How you doing?
No, I'm pretty sure that that's what we did.
Ms. Lewis, you're on a need to know, apparently. You're a need to know basis.
Yes, that's what I have. Is that wrong? Okay.
I don't recall it, so.
She's telling me it's right, so, okay.
Okay.
And I still have the plea date as the 11th.
I think that's it, as far as I know. I just knew that the trial had been moved to April. Okay.
Got anybody back there? Go ahead and bring them up whenever they're ready. I'm gonna keep trying to go through all the rest of them until then, so.
We got one ready for plea.
All right.
It's Miss Endexler Sweeney.
Who?
Endexler Sweeney.
She back there?
She is, Judge. Judge, I can pass the files up there.
What's she guilty? What's she guilty of? What'd she do?
But I've been handed, Ms. Sweeney has a number of cases. I've been handed, we'll go through them in the order they appear on the docket. Docket number 22, CR 104. On her plea of guilty to count 1 aggravated burglary, she would receive a sentence of 8 years suspended to state probation. Condition of her probation will be to stay away from John Norman. She must complete the 1-year Mending Hearts program. Count
You have her
2,
boyfriend.
aggravated assault. She would receive 8 years suspended to state probation. And that would be concurrent to each other and concurrent to 2023 CR 312, but consecutive to case number 2022 CR 310 and 311.
Leslie,
Right.
the White Rabbit is out of town, and it's been 1 year since
Docket number CR
Brown Dog
310. She would be pleading guilty to misdemeanor
blew out his
theft
ACL.
and would receive a
I think
sentence of
you
11
were
months
here
and
when that
29 days.
So,
That's
yeah,
how
I'm in
receive
charge
the,
right now, and
sentence to time served in
hey,
this
honestly, I'm a
case.
little nervous, but they're doing fine.
With
They're
jail
doing great.
credit
I
and
came in and said,
case
"All right,
was
guys, Mama's
concurrent
gone.
to
It's just us."
2022 CR 311.
Brown Dog took off, jumped up on the
311 would be
couch,
misdemeanor
grabbed
theft.
a pillow off
Would
of
be
it, and
pleading
headed to the
guilty to
stairs.
that and receive time
Like,
served with credit for time
I think
served.
maybe he'd at least take the pillow out for dinner.
And docket number 2023 CR 312, aggravated assault. She would receive a sentence of 8 years suspended probation. Stay away from Richard Niner. Complete the 1-year program at Mending Hearts. That would be concurrent to 2022 CR 104, consecutive to case numbers 310 and 311. Sweeney, raise your right hand. Let's place you under oath.
Yes.
State your full name for the record.
Ashley Sweeney Ann Dexler.
Ms. Sweeney Ann Dexler. Is it Sweeney Ann Dexler or Ann Dexler Sweeney?
Sweeney's my maiden name and Dexler's my married name. They just have me under both. So I Sweeney Ann Dexler.
So we can use them interchangeably. All right.
Yeah.
The indictment, or at least the docket, showed the Ann Dexler was first and so forth. All right. Have you seen or been shown a copy of the charges that are against you and talked them over with Mr. Saul and discussed with him the range of punishment you're facing as well as any possible defenses you might have?
Yeah.
Well, it's indicated that you want to enter a plea of guilty to these charges. And so, do you understand you have a right to plead not guilty and have a speedy public trial by jury?
Yes, sir.
Do you understand that at that trial, you would have the right to have a lawyer and have one appointed for you if you could not afford your own?
Yes, sir.
Do you understand at trial, you'd be presumed to be innocent until such time if ever the state proves your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors? Their verdict would have to be unanimous before you can be convicted.
Yes, sir.
You understand at trial, you and your lawyer could confront and cross-examine all witnesses the state might call to testify, and you could bring in your own witnesses by the use of a subpoena.
Yes, sir.
You understand that trial, you would be presumed to be innocent. You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial. You understand that if you went to trial, excuse me, and you were found guilty, you could appeal the conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal.
Yes, sir.
You understand that by entering this plea of guilty to these charges, you're waiving your right to a trial and to an appeal. And all I'm going to do is approve what your lawyers worked out to dispose of all of these cases.
Yes,
You
sir.
understand that? You understand everything I've explained to you?
Yes, sir.
You understand that's going to result in a number of convictions, some felonies, some misdemeanors. Those convictions will be on your record in the future to make more severe the punishment you'll receive if you're ever again convicted of a crime.
Yes, sir.
You understand if you plead guilty, the court of the state could ask you questions about these offenses, and if you answer the questions under oath on the record and in the presence of your lawyer, your answers can later be used against you in a prosecution for perjury if it turns out you're lying on the oath.
Yes, sir.
Is your decision to plead guilty today voluntary?
Yes.
Anybody forcing you to do this against your will?
No.
Do you understand I can't accept your plea unless I'm satisfied you're guilty and there are facts to support it?
Yes, sir.
And I'll ask you now in docket number, are you going to give me the factual basis, Mr. Brooks, or do you want me to ask her? First of all, are you guilty of these charges of aggravated burglary?
Yes, sir.
And what about the aggravated assault apparently against John Norman?
Yes, sir.
Tell me what happened there.
It was a fight. I was on parole. It was me and my dad. My
Is
dad,
John Norman your dad?
no, he was it was me and my dad together. My dad's my co-defendant.
Oh, okay.
Yes.
That's the other Mr. Sweeney?
Yes,
So he got into a fight with John Norman?
Yeah.
All right. So was he injured or was there a weapon involved?
there wasn't a weapon involved, but he was injured, yeah.
You got hit over the head with a beer stein, Your Honor.
A beer stein? So we have, how many Westerns have I seen where that actually took place? It's not funny. I mean, it's not funny at all, especially if you're the person who's getting conked by a beer stein, but it's almost like a quintessential barroom fight. So. All right, misdemeanor theft, are you guilty of that?
Yes, sir.
All right. 2 counts of misdemeanor theft, you're guilty of both of those, I assume. And then there's another charge of aggravated assault on a Richard Niner. Tell me about that. Are you guilty of that?
Yes, sir. It was a fight. There wasn't a weapon involved, but he was hurt, pretty bad too. My dad's my co-defendant in that case too.
Mr. Niner sustained a broken eye socket, broken nose, and numbness to both left sides.
What was this fight about?
Apparently it was over a cell phone that my dad had taken from him. I got called to the hotel because my dad's got mental problems. So they called me there to come try to calm him down. It didn't go so well.
Do you have any other factual basis that you want to add to any of that?
In both ag assaults, she breaks into a hotel room here in Dickson County and assaults the victim. They're both over alleged thefts from those victims. Your Honor, the only thing I want to note is that there's not a place on the plea form that's amended yet, but the new ag assault, the most recent one, that is 100% if she serves. So the plea.
So if you violate it, what that means is that you would not be serving 30%, you would serve 100% of that sentence, that 8-year sentence. But that only applies if you violate your probation and go to prison. If you stay out of trouble, you won't have to worry about that. But you need to understand that. If you violate the newest of these cases, which would be the aggravated assault found in 2023 CR 312, then if you violate the probation of 8 years, then you could serve 100% of 8 years in jail instead of 30%. You understand that?
Yes, sir.
As long as you stay out of trouble, you won't have to worry about it.
Okay.
So, all right. And are you satisfied with your attorney services?
Yes, sir.
You feel like Mr. Saul's done a good job of representing you confidently?
Yes, sir.
Saul, you know of any reason she should not enter this, please?
No, Your Honor.
Sweeney, I know you may be close to your father, but you might want to stay out of any situation that he puts you in that could land you in prison for 8 years. You understand that?
Yes, sir. I moved. I've lived in Nashville for over a year now. I don't come around.
Then Ashley Ann Dexler Sweeney, or Sweeney Ann Dexler, I find you guilty on count 1 of 2022 CR 104 of aggravated burglary, sentence you to 8 years, Tennessee Department of Corrections. That will be suspended. You're ordered to stay away from John Norman, and you must complete the 1-year Mending Hearts program as a condition of your probation. Count 2, you're found guilty of aggravated assault, sentenced to 8 years, suspended to state probation. Those sentences will be concurrent to 2023 CR 312, but consecutive to 3110 and 311 counts. Docket number 310, you're found guilty of misdemeanor theft and sentenced to time served with credit for time served. 311, you're found guilty of misdemeanor theft and sentenced to time served with credit for time served. 312, you're found guilty of aggravated assault, sentenced to 8 years, suspended to state probation. You're ordered to stay away from Richard Niner. You must complete the 1-year Mending Heart program. That is also concurrent to 2022 CR 104.
Yeah, don't get in fights on parole.
Consecutive to 310 and 311. That's the judgment of the court. Thank you. She'll need to see the probation department at some point. So,
Thank you, Your Honor.
you have anybody else back there? Bring them out. Mr. Spratt, you wanted Courtney Cox brought down here.
No, Your Honor, we took care of that. I think that's gonna be passed to March 12th for her plea date.
Oh, thank you. Mr. Sensing, you have a motion withdrawing an Adam Curtis Dansby Frazier that's in the Department of Corrections, and they have not apparently transported him, have they?
Judge, for the moment, I'm just gonna strike that motion. I may
Motion is struck.
refile it, but
That's fine. We'll let you strike it. Thank you.
the gentleman they're bringing out now is Nathan Claude Wall. That would be CC 23CR 251, 252, 253, 254, 255, and 256. Judge, this is set for, I think, a plea on the 12th.
I'm here. I'm
not
just going to take my
mistaken. It's a
image off for a
The
second.
situation is
Okay.
we were trying to get Mr. Wall in the drug court, but unfortunately he wasn't able to get in. And so that's kind of left us a little bit scrambling on settlement, which we're continuing to work out. There's, as the court I'm sure can infer, a lot of moving parts going on with this case. So we are being diligent in trying to get something worked out. But if we could just either set it on the 1st or leave it on for the 12th for plea, if that works out for the state. I think that by the 12th, we should be able to get something done.
We'll leave it set for final plea day of March 12th. Trial date remains March 22nd.
Thank you, Judge.
Thank you. We have on here a 2023 CR 317 State versus Curtis Lee Dudley. And I have recused myself from that case. He's a
There's
former
Brown
client.
Dog sleeping.
Don't know why it's still set for my trial docket, but it should be.
And Judge, since you brought that one up, I'll go ahead and address it. I've been speaking with General Bryson. It's her case, Judge. I was kind of curious of the same thing, but I was also curious in terms of he was set on the status date, but yet there was no plea date and then subsequent trial date in his case either, which is why I was trying to get this case resolved. Is that he doesn't have another date other than the trial date. It's still your
When's
Honor's
his trial?
trial.
Well, I'm just telling you, he doesn't have a trial date with me. Mr. Dudley and I have a long.
Let me see if I can
history.
find a
Before. I know he's done work. in
little
my
tripod.
home,
Mine as well,
for
Judge.
business, and I'm not gonna, it would be unethical for me to hear his case.
I
So
agree.
the March 7th date does not apply. We just need to set him a new trial date in front of one of the other judges.
May the 3rd with April 24th to plea.
May 3rd, April 24th for a plea. Right.
Thank you, Judge.
Thank you.
Get out of here. I'll call you.
Kimberly Corlew Dawson, that's Mr. Wainick's case.
State's gonna nollate that case, Your Honor.
Nolly by the state, dismissed. Anybody else like that?
He's bringing out Code Francis.
Right. (2023) CR 297 State versus Jefferson, Sean Eckford. Mr. Eckford, this is the day that you were told to come back and let us know who you've hired as a lawyer. Who have you hired?
Yes, sir. I had, Chris Clark was counsel and, I lost my job working out of town, so I need to see if I can get a public defender.
Raise your right hand and be placed under oath.
Yes, ma'am.
All right, fill out this form. You're signing it under oath, so make sure it's accurate under penalty of perjury. We'll come back to you sometime this afternoon.
Yes, sir. Thank you.
All right, now, Mr. Howard. Cody Allen Lee Francis.
Yes, this is Mr. Cody Francis. He's been kind of bouncing around county to county. He's currently housed at Hickman County. I tell you that to say that we need to reset him. I'm handing him a drug court application. We would like to look into that. However, he has a matter pending in Hickman County that I think is going to be arraigned around May-ish, speaking to the public defender over there. If we could set this sometime after that to kind of get that
There's
out.
a trial date of April 15th, right? And that's what you're asking me to reset as his trial date?
The plea. I think we can get this worked out, but it doesn't do us any good to try to get him in recovery court if he's gonna have a hold in Hickman County.
Steve Gosney suggested this book.
State have any opposition to resetting the trial date?
No, Judge.
When do you want to reset it?
Did she give you a date?
Just sometime after May is good for me. Whenever it works for y'all.
Judge, can we give it a status date?
Sure. August the 20th.
Thank you, Judge.
Thank you.
Yeah.
State versus Pedro Garcia, Perdo Garcia, 2023 CR 46. That's Mr. Wanick's case.
I just saw Mr. Wayne.
Judge, that case is on for plea. I believe it was March 6th for plea.
March the 11th for plea, March 19th for trial.
Let's leave it set if we can. I believe we're gonna work something out. We'll know by the plea date.
March the 11th.
Thank you, Judge.
Whenever you get somebody to bring more. State versus Cordarius L. Godwin, Mr. Spratt, docket number 2020 CR 192.
Judge, that's my motion to revoke bond.
Well, I would assume it's going to take a little bit of time for that. Is that correct?
Judge, I will be entering certified copies and new charges. I don't have any testimony to present.
I'm gonna object to that, Judge. I think under bargains, the state doesn't have a live witness. I was told that they would be here. I've had this issue come up before, but I think the state versus bargains case is clear. that
State versus what?
Bargains.
You got the citation for
No,
it?
Your Honor, I'm sorry.
Well, Judge, here, I'll provide you a copy of Judge Easter's order the last time Mr. Spratt appealed this issue.
I haven't seen it.
You're saying this is an issue that's been raised before?
It's an issue that was raised before, Judge. The Bargains case is a Tennessee Supreme Court case. That is 464 Southwest 3298.
Wait a minute. 464.
Southwest 3rd, 298.
All right, well, we'll take up Mr. Godwin's case after lunch. I've got time to take another plea, but I don't think I'll have time for this hearing. I need to read the case law on it anyway. So.
Judge, that would be after that federal case management conference. I'm afraid federal judge throw me right in jail, so I kind of have to walk out for that. So it could be 3:30.
We'll get to it as quickly as we can, but we will not be staying past about 4:30. Sensei?
Yes, Judge, I see that the BS brought out Ms. Tiara Lane Bethke. That would be in CC 22CR231.
What was the last name? I'm sorry.
Bethke, Bethke. Hi, Mr. Howard, I'm operating off the wrong sheet of music, I'm afraid. This was set for status today on a case that I inherited from Mr. Mitchell that was just kind of being set for rehab reviews. Unfortunately, Ms. Bethke has picked up some new charges, and therefore those charges are set before Judge Wallace on April 24th for plea. So I would just ask the court to set this for status on that date. I believe we should be able to work out a global settlement. I understand that there's a drug court application.
All right, April 24th.
All right, thank you, Judge.
Briefly, if I can, try to knock something out.
Real quick. Come up, Mr. Jackie.
Yes, Judge.
Let me knock him out.
I don't know that would be beneficial.
Come up here. I'm not gonna bite you.
I'll be more than happy to come on up.
And who is the DA in your Dudley case?
It's General.
General Bryson, would you come up, please? Just received a text from Mr. Dudley saying, good to see you again. He has my number from when I represented him many years ago. So I'm just making you both aware that I am not responding to it. He's a nice guy. I have no problem with it. He may not understand.
They left the mics on earlier when Judge Wolf had to do a
He did say he's still
conference call with an issue dealing with family law. I love this. This is the side of the bench that you don't get to see.
New house under construction, you might want to check.
You're not alone because I showed you my floors. So
I don't take it wrong, but I'm duty bound to advise you that my former client has, who I just recused myself from, decided it was okay to
Okay.
take.
That's not right. Good to see
Now,
you.
Mr. Spratt.
Judge,
I don't have today's docket handy, but I have a case on here, State versus Colton Lyons, 2023 CR 71C. I believe that was set for status yesterday.
Lyons?
Yes, sir.
15.
Judge, I don't have a.
So on page 15.
Yes, sir. I don't have a settlement on that, but I'm showing a March 1st trial date. And so that's what I'm understanding is that there's motion dates. So, I mean, Mr. Lyons is here. He's just whatever you want to do. It's General Wojnarowski's case. So I thought maybe we could.
So this is a simple possession and evading arrest. It's not one of the conspiracy cases, correct?
No.
Let's give Mr. Lyons, because General Wojnarowski has some dates that I think we gave her in, were they August?
There are co-defendants. I don't know if they've been given new dates or not, but I would assume they need to.
Co-defendant in evading arrest and simple possession.
Yes. You have 2 cases.
Well, but there, I think he may have more than one case, because the 4 co-defendant case is 23 CR 71.
And when are they set?
They're all still on March 1st for status, I think, believe.
For status? Well, that's fine with me. That was gonna be my suggestion. We'll just come back on March 1st for status. If the
The
court,
other 3 defendants are.
Although
on
someone else
today's
comes with the
docket,
idea and the
so
attorney
that
says,
may
that's gonna be my
change.
suggestion.
They're all 4 on today. Let me see what we got in this one. So we left on March 1st.
Let's just leave it for March 1st and then we'll determine whether or not we need to do anything different. Mr. Jackson, you're standing up. Can I do something for you?
Yes, Your Honor. I apologize for being inappropriately dressed, but I didn't know I was gonna be here today. I have a motion for a temporary restraining order I'd like for you to consider.
Ooh, a
All right,
TRO.
I'll take a look at it when I take a recess.
You'll be fine. Thank you, Your Honor.
You want to hand that to the officer? Anybody have anything quickly in the next 2 minutes before noon?
I'm Peggy Haskins, late.
I can't hear you from back there. If you want to say something, come up front.
Yeah, she was on yesterday's docket, and she didn't show up till noon. So we told her to be back there at 8 o'clock, and she is.
I'm here.
What's your name?
Peggy Haskins.
Court I represent.
On page 13.
Yeah, she's not here today.
Ms. Fordyce is over in Cheatham County. She got the Zoom link, so she will be appearing, but
By the way, Dickson County is on Central Time. I'm on Eastern, so there's an hour off. Wendy, yes. You can call me on Discord if you want to talk. As soon as you're getting ready to go to lunch, and I have to I have to run out of here. Are you going to be available in, say, 15, 20 minutes?
Good afternoon.
Good afternoon. You have a motion to withdraw in a Katie Haskins case?
Oh, she wants to withdraw?
Ms. Fordyce, I know you were appointed to represent her, and your basis of your motion is that Ms. Haskins is not, you had no contact with her, if I understand correctly.
I can't hear you, Your Honor.
I don't know what the problem is, but we may need to rejoin this after lunch. So let me send her a message and just say.
Don't mess with the judge's lunch. They are adamant about that.
Send me a message?
Can you hear me?
Yes, sir.
Okay, I'm sorry. I thought you couldn't hear me.
I couldn't for a minute. Now I can.
This doesn't surprise me. This is Ms.
amazing
Haskins, who's
technology,
here
but
today.
it messes up all the time.
And you have a motion to withdraw from her
Discord's
cases.
the worst.
And I'm just trying to determine, is the only basis for the motion that you've had no contact with her? She's
That
not.
is correct, Your Honor, and I waited to file it yesterday and I stayed in court till 11 o'clock. And she evidently appeared afterwards. I had made calls to the bondsman and everything else. And I guess I'm further disappointed because her bondsman told her to get in touch with me and I still haven't heard from her. And I've sent letters. She has a very small offer in this case, but I can't represent her if she's not willing to call me.
Ms. Haskins, why haven't you contacted your lawyer?
I just now got me another phone. I haven't had one, and that's no excuse. But I called her once a long time ago, like when it first court date.
You have her number?
And yes, sir. And I had it
Call her
back
from any
then,
phone.
and I called her once, and nobody answered. I left a voicemail thing, and I just never called back.
Ms. Fordyce, this is showing that it's set for a plea agreement or a plea status on March the 1st. If you are, I know you're in Ashland City right now. Are you going to be in court this afternoon?
No, sir, I have a hearing still in Cheatham County at 1 o'clock that was set. I will be in Dickson County on March the 1st.
Yeah, that's your
Well,
responsibility.
is there a time, I want to arrange a telephone appointment for this woman. She has your
I
number.
forget everything.
She says she now has a phone. So we're going to set a specific time for her to contact you so that you can discuss with her the offer that's made. And then we'll come back on March the 1st. And if she hasn't contacted you, I'll relieve you and she'll represent herself.
Let's tell her to call me at precisely 4 because I know I'll be done for sure from that hearing by then.
For today?
4 o'clock today.
Okay, I'm gonna read off your number to make sure it's yours, okay?
You might, well.
Oh, whoops.
Let's just do this. Step outside and call that number right now.
Okay.
You got your phone. Your phone's in the car.
No, I'll have to use Mr. Tummins real quick.
I have Ms. Fordyce's number. I'll confirm it with her.
Just confirm the number
Just
for
go
Ms.
sit down.
Haskins.
All right, thank you. Sorry.
Ms. Haskins, come back, please.
Let me sit down. Sorry. I'm confused.
We need you back in this courtroom on March the 1st.
Yes, sir.
Okay? Now, I don't know if you're taking any kind of medication or anything, but
No,
your
sir.
eyes, just
Are you
listen to
taking
me.
medication?
Your eyes appear that you may be slightly under the influence, not significantly, but slightly. So when you come back here on March the 1st, if I have any indication that you might be under the influence, I'm going to have you drug tested. You understand that?
Yes, sir.
I'm not doing it today because this is basically trying to get you with your lawyer. But if you come back to court with a drug test that's positive, you will go to jail for 10 days for contempt of court. I don't want to do that. I want you to get your case taken care of. Ms. Fordyce is a very good lawyer, but she can't help you if you don't help yourself. You understand that?
Yes, sir.
This is all now on you. So 2 things. Do not come back with any indication that you might be under the influence of an intoxicant. Second, be here March the 1st early, before 9 o'clock. Third, talk to Ms. Fordyce today at 4 o'clock. Let her convey to you the offer that's made and decide whether or not you want to take it. I don't care if you do or don't, but I'm going to set you a trial date on March the 1st if you don't take it. And that will be to either go to trial or plead to the indictment and go to sentencing. So this is going to be March 1st is your last day to settle your case.
Yes, sir.
So, everybody understand?
Yes,
Joe,
sir.
you're going to step out and give her a
I
confirmation.
just want to apologize for not getting a hold of you. That was, bad on my part. I take full responsibility. I'm sorry.
Okay. Well, doesn't matter whether you apologize or not.
We got to remember that word, Jen.
Suggest that you leave and get your system cleaned out before March the 1st, because I'm fairly well convinced that you're under the influence. You may have a prescription, but if you come back to court with any kind of intoxicant in your system, you are going to jail.
Yes, sir.
We'll stand in recess until 1:15.
I like that you didn't
Well, let's take it
separate those
1:30
two.
because I've got
Prescription and
to deal with
intoxicant.
some things.
He said you may
All
have.
rise.
Well, I'm gonna stood
Court's
up.
now in
I wouldn't
recess
be able to
until
stand
1:30.
up. Oh my gosh, y'all! I'm not a fan of going to court. There's a reason why. 10 days. Could you imagine spending 10 days in jail because you smoked a joint 2 weeks ago? Oh, I think it's so funny. All right, they're going to lunch. I need to get out of here for a second. If come back, they're still doing, I'll shoot another stream. This is fun. I want to get into this. You guys can tell I'm feeling better, can't you? Let's see here. Hang on. I want to do something real quick if I can do it. Stop that one. And then let's share screen. Let's see here. Can I share? No. Why is that not doing window? Allow. Guys. Brown dog. There he is. He's right here behind me. That's so cool. Can I do that? Nope. Oh, I messed it up. Mess it up. Well, that's not good. That's better. Boom. No, I don't like that one. I definitely don't like that. We'll just go with that. There we go. Brown dog. Mama has left him in my care. Blue dog is on the master bed. So, hey, Ramen, what's going on? Haven't seen you in a while. So yes, blue dog or brown dog is here. I need to change the name of the camera to Doggy Cam. That'd be cool. No, you tell my camera name up here. It says white camera because I got it's white. I've got a black camera too. I want a camouflage one. All things camouflage. Anyway, all right, guys. Yes. Hey, bud. Leslie says, Mama needs you to be good. And you are a good boy. See here. Oh, gosh, he's further away than I thought. Oh. Hello. Hello. Oh, hey, Bubba. I'm going to fall out my chair. I do not want you guys to see me fall out my chair. There we go. All right. Mrs. K. Grift. So happy to see you again. How are you doing? Yes, we are coming back. I've got to, I'm getting ready to say the G-O word. Could you guys hear that? Did you hear that groan? Oh man, I'm in trouble. Anyway, yes. So I'll come back. I'll shoot up another live one if Dickson County comes back on. It should. He said it's lunchtime. So I will be back here in a bit. And I kind of like this camera situation here. I may have to figure this one out. I said OUT. And he's gone. All right, guys. You're doing better. Hope to get back streaming soon. Awesome. If you're not doing anything this afternoon, come on. You're welcome to hang out. But Wendy, I'm going to I've got to load up the car. Load up the dogs into the car. I gotta go. I will call you on Discord. Okay. And I hope it all works out. I'll be back soon, guys. Love y'all. Thank you so much for hanging here. And you know what time it is.
I woke up to go get me a cold pop, and then I thought somebody was barbecuing. I said, "Oh Lord Jesus, it's a fire." Then I ran out. I didn't grab no shoes or nothing, Jesus. I ran for my life. And then the smoke got her. I got bronchitis. Ain't nobody got time for that. Ain't nobody got time for that. Ain't nobody got time for that. Ain't nobody got time. Ain't nobody got time. Ain't nobody got time for that. Ain't nobody got time for that.